Your Honor, he kind of interrupted me. Am I able to speak a little bit more on my behalf regarding this, or?
Yeah, he didn't interrupt you. You were interrupting him when he was speaking.
Welcome to Rebel Chaser. My name is Gail, and this clip comes from Judge William Baillargeon at Michigan's 57th District Court in Allegan, Michigan. It's a little bit different than what I normally do, but it's a motion to sign over title for a land contract. But as you'll see, the person that is living at the property has not done several things that she needs to do prior to the original owner signing over the deed. I'm kind of anxious to hear what you guys think about this in the comments.
Let's call the matter of Lauren Hazard versus Heather Stevenson. All right, let's have appearances, please.
Peter Taylor on behalf of Laura Buxton and Lauren Hazard, Your Honor.
All right, and on behalf of the defendant?
Myself, Heather Stevenson. And I also have my realtor here with me as well to speak on my behalf if we have a chance.
Well,
I guess I would object to a realtor acting as an attorney.
Well, I would object too. I mean, we can't have it unless you're a realtor is an attorney. I suspect this is a matter where you'd like to have an attorney representing you, but I'm going to ask you, ma'am, did you file a response to the motion?
He did not send it to me until Saturday. I didn't get it in the mail until Saturday. I'm the one that filed the motion though.
It was her motion, Your Honor. It was Ms. Stevenson's
motion. When is your motion scheduled, Mr.? All right, so
I filed. Am I heard as well?
What's that?
Am I heard as well?
Who's heard? Who is this?
My name's Eric Eckhart, the realtor. I was here for support. Someone had told Heather that it would be good if I were here as support, but I am not an attorney. So if I should not be here, I can leave the conversation.
Yeah, I mean, I can't have you speaking on her behalf, sir, unless you're an attorney.
Okay. All right. Well, Heather, I'll talk to you later.
Thank you, Eric.
Yep. Okay. Bye-bye.
So,
I guess I was
all right.
Advised wrong. I advised wrong, so I apologize for that.
What's that?
I said I was advised wrong by the attorney, so I apologize for that.
So, Your Honor, I believe Ms. Stevenson filed her motion to enforce on the 1st of September, and then the certificate of mailing went out on the 5th. I received that last Monday on the 11th, and my response to her motion to enforce was dated September 11th. Or I'm sorry, September 12th. Which would have been last Tuesday.
All right, well, ma'am, you can go ahead with your motion then.
Okay, well, I don't have an attorney with me, but I have talked to 4 different ones and I've been given the same advice from all of them. But anyway, I'm here because I obviously have a judgment against me because I owe on the land contract, and I was given 90 days to remedy the situation, which I had informed you I was going to put the house up for sale, let the seller know as well. And I have received a sale over a month ago, offer, and Lauren is refusing to sign the deed over because she wants the equity of the home. And my understanding is she's not entitled to that as long as she gets what I owe her, and then I am to keep the remainder of the equity. The attorneys have advised me of this, and also I've talked with the home title company as well, and they have confirmed this too.
Mr. Taylor?
Thank you, Your Honor. The parties entered into a land contract on February 28, 2018, which was attached to our response, was the subject or initial filing that's in the court file. That had a 5-year balloon payment on it, which was due February 28, 2023, on which the balance to be paid was approximately $147,000, a little bit more at the balloon payment date, February 28, 2023. Ms. Stevenson did not make that payment since February 28, 2023. She has not made any further payments on the land contract. She's continued to live in the property. Paragraph 16 of the land contract provided for that balloon payment. Paragraph 3 of the land contract states that the buyer shall pay prior to delinquency all real property taxes and assessments of any kind or nature levied. Heather Stevenson's failed to pay the property taxes in the amount of $3,185.84. But most importantly here, paragraph 13 of the land contract states that the parties expressly agree that in the event of default not cured by the buyer within 15 days after notice of intent to forfeit the contract is served upon the buyer, seller shall have the right to possession of the property and to receive all rents and profits relative to the property from and after the date set in said notice for curing such default, and such right of seller shall continue during any period that forfeiture or foreclosure proceedings may be pending and during any period of redemption.
But so are you saying by that then that the redemption period then is abrogated and the defendant is reduced to a 15-day redemption period? Is that what you're saying?
No,
That's what
no,
it's
Your
telling
Honor, we're not changing the redemption period.
You're
What
just
we're-
changing the fact that if indeed she does pay it off, you guys still get like some sort of profits associated with that? I mean, I don't understand.
Yeah, well,
Yeah,
if
and
she's,
that's
if,
only for rent.
Miss Stevenson.
That's
Miss
if I'm
Stevenson,
running the
Miss
property.
Stevenson. Miss
Sorry.
Stevenson.
Yeah, I said I'm sorry.
Yeah, I know you said you're sorry. You said you're sorry a couple of times, but each time you were interrupting me.
I apologize.
Mr. Taylor?
the contract was not changing the 90-day redemption period. What the contract is saying is that Heather Stevenson, during the 90-day redemption period, she can come with a check for the amount that's been owed on the forfeiture. And she's not coming with the check. She's coming saying, hey, Miss Hazard, you need to come convey this property to a third party, and then I will give you my check when you convey it to a third party.
Until the end of the redemption period, doesn't she have the ownership right to sell that then?
And the contract says that any profit derived from the sale goes to Miss Hazard.
Yeah. You have support for that?
Yeah, well, I have the contract, which I cited.
You have case law support.
Sure. Well, did you see on paragraph 23 of my response?
Do you have case law?
I'm going to cite. So paragraph 23, this is quoting.
Wait a minute. You're talking about paragraph 23 of your response?
Yes, where I cite case law.
So that might be a problem here then, because I don't have. Oh, wait, there it is. 23. 1 second. I'll catch up to you. All right, go ahead.
Sure, thank you. So it's Gruskin v. Fisher, which is a case from 1979, states that the seller must make a decision under the statute is to put to an election of remedies. He may accept possession, or if he wishes to obtain a deficiency judgment, abandon the summary proceedings in favor of a foreclosure action. Here, obviously, Ms. Hazard has chosen the summary procedures and did not pursue a foreclosure action. However, the purpose and effect of a valid declaration of forfeiture, this is in paragraph 25, and that's Chicago Boulevard Land Code v. Apartment Garages from 1929. So the purpose and effect of a valid declaration of forfeiture are to end the contract and discharge the vendor of the duty to convey and the vendee of the duty to pay. So Ms. Hazard does not have a duty to convey the property until Ms. Stevenson shows up with a check for the amount. Miss Stevenson's not showing up with a check for the amount. She's calling and saying, hey, you need to come convey this property to a third party. And then at that point, I'll present you with a check for the valid amount. And Miss Hazard doesn't have an obligation to convey the property to her anymore.
I don't know. That seems like an undue enrichment.
Wouldn't
I
the court-
guess what I'm gonna do is take the matter under advisement, because I'll look up your case law, I suppose, and I'll read that and then make a determination once I read your case law on that.
Thank you. And I did.
But right now, I'm thinking that she has a right to convey the property and to satisfy the redemption, but I might be wrong.
And I did attach a unpublished case that I cited as well. Your Honor,
Okay.
which did cite.
That's fine. I'll review that as well. Okay, so I'll take this matter under advisement. I'll issue an order forthwith.
Thank you, Your Honor.
Your Honor, he kind of interrupted me. Am I able to speak a little bit more on my behalf regarding this, or?
Yeah, he didn't interrupt you. You were interrupting him when he was speaking.
Well, I wasn't able to say what I was going to say. I'm sorry.
Well, I let you speak until you were finished. What else did you have to say, Ms. Stevenson?
Well, I just wanted to make you aware that we did have a written agreement that we were going to renew this land contract up until 30 days before my balloon payment was due. And
Well, that's it. But if
she
you
did
didn't,
this out of bad faith, I think.
but if she didn't renew it, it's not renewed, right? So you don't have a renewed one. It's the original.
Yes.
So I can't.
She had an informed.
Go ahead.
I was just going to say we had an appointment set up with the attorney for February 16th to do it.
Okay, and
I had lost my father. I was taking care of him. She knew my situation.
And it didn't happen, correct?
No, it didn't. No.
Okay. Anything else?
I feel like she acted in good faith and did it on purpose until the last minute. But anyway, that's besides the point. I just feel like she wasn't acting in good faith, and she led me all along to believe that I even have texts from her saying that she was going to do anything to help keep me and the kids in the house. And then her daughter decided to take everything over and send me a letter 30 days before my balloon payment was due, knowing that I couldn't get financed. And that's why we were going to renew it.
Okay.
She's doing this.
Yeah, it doesn't sound.
I apologize for getting emotional. I'm just.
Oh no, that's fine. But my point is, I agree. It doesn't sound. Well, it will certainly be an interest. Ma'am, I'm going to review with interest the case law on this. It doesn't sound ethical, but just because it's not ethical doesn't mean it's not legal. So she may obviously it could be unscrupulous, but it might still be legal. So if it is legal, my hands are essentially going to be bound in regard to that. But if it's not, then I'll make that decision accordingly. But obviously one thing that is not relevant, I'm not trying to sound cold, but, it's a situation where interests like this, if you have a situation where you believe there to be significant legal issues involved and you've consulted with attorneys, frankly, ma'am, it would be in your interest to retain an attorney or to have an attorney represent you in some way, because obviously this is a significant matter. And so you make it very difficult for me to make decisions. I'm certainly not going to make a decision based on people that come into the courtroom and exhibit emotional pleas that are contrary to the law. I understand people are in difficult situations. I understand people have families. I understand you feel taken advantage of. But, if it indeed is the circumstance that pursuant to the contractual language that was inserted into this land contract and the enforcement mechanisms are, as Mr. Taylor had outlined, however seemly they may be or unseemly they may be, the point of it is, if it's legal, I'm going to have to, allow it.
Yeah, absolutely. No, and I would have retained counsel, but I consulted with 4 attorneys and they all told me I didn't need to because it was all cut and dry. And it was in my favor. Otherwise, I would have done that, And my understanding is that rent and profit.
It's not so cut and dry. Not so cut and dry. I'll take the motion under.
Thank you, Your.
Okay. Thank you.
You're welcome.
Well, she talked to 4 attorneys and they all gave her the same advice. And not one of them told her that she needs an attorney. I think that was probably the most important thing. She needs an attorney. She should have had an attorney before she signed the contract, and she should have an attorney representing her here. I don't buy that none of those attorneys told her that she didn't need an attorney. I'm not buying that one bit. I doubt she talked to several attorneys. I don't know. I think she may have talked to a realtor, the guy that she had on, that she tried to bring on. But she didn't make the 5-year balloon payment. She hasn't made any payments since February, and she hasn't paid the taxes. So if I was the title holder, I don't think I would sign over title either. I mean, she hasn't done all the things that she's supposed to do. And then she talked about, well, we were renegotiating the contract. Well, then what happened? Did you just drop the ball and just say, screw it? Well, if you said screw it, well, then screw it. You don't get it. And now she's coming back and saying, well, I want the equity. Well, you haven't made a payment in 7 months. I don't know. It just doesn't seem right to me that this woman should get the equity when the true owner, title holder, is the one that took the risk. Because this woman just threw up her hands and said, I'm not going to do this stuff. That's my opinion. I don't know. What do you guys think? Let me know in the comments. Thank you so much for watching, and I'll see you next time.